any mention?
Your Lordship, I beg to mention item 34 and 35, Your Lordship.
Item
34 and 35, Your Lordship. Connected matter.
34 and 35.
Yes, Your Lordship.
34.
This matter can be taken out
Why?
after 2 weeks, Your Lordship.
No reason.
Personal difficulty.
Mr. Shulai,
Let it come on 23rd then, Your Lordship.
some urgency is there.
Urgency is this is
23rd, no. He'll go to after 19 June. Is that all right?
all right.
Yes. Just after 19 June. Because this code won't be available for a long time. Yes.
Oblige, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item 6 from the supplementary cost list, Your Lordship.
Why?
The conducting
Today to a
counsel-
small point because this matter will be disposed
Your
of today. Where's Mr. Dr. Mozika? What happened?
The accounting council is our station, Your Lordship.
It's your case, fine. Yes,
1 week time, Your Lordship.
4 weeks. 4 weeks, yes, out of 4 weeks on the prayer of the council petitioner. Yes.
Highly obliged, Your Lordship.
Item number 33 has taken some time. 33.
33?
Petition.
Oh, yes. No objection. 33, Mr.
No.
Yes.
But there is
And the request with the council for the petitioner list also.
there's another matter also pending concerning education department. There, I think perhaps some correction is required.
Some?
It's all right. It's all right. It's all right.
Yes.
Oblige.
Your Lordship, I beg to mention item 37.
30?
37. Lordship, I'm praying for 2 weeks' time.
37.
37.
Abdul Hashim Sheikh,
Yes, Your Lordship.
MS Iwanyang. Why Ms. Shangri was not here today?
Your Lordship, the conducting council is having some difficulties.
Yeah, to pursue difficulty conducting council. This is a matter also.
Highly obliged.
Yeah, Mr. Basmatari.
I beg to mention item number 32, Your Lordship.
Why is partnered?
Yes, Your Lordship. Maybe on the next week, just
Why?
pass over for the day.
Who's there for the other side? What is the matter about? Why is it partnered?
My lord, this is a matter, my lord, where he was reverted back. My lord, he was a poultry farm assistant. Subsequently, my lord, he was on officiating basis.
Oh, right. Where, there's another counsel appearing for the private respondent. You are appearing. Where's Mr. Qureshi?
He's having some personal difficulties.
Okay. Due to personal difficulty of the arguing counsel? Yes, also, yes.
Oblige, Your Lordship.
Give your Lordship's indulgence to make a mention, Millets, of this item number 39. This is that matter concerning that Majai Export Land Custom Station, Millets.
I'm the main respondent, Your Lordship.
So, if your Lordships are kindly pleased to...
What remains here, Mr. Paul?
Well, as I had submitted before your Lordships,
Small question.
the only legal issue survives for adjudication by your Lordships, my Lords, which would otherwise have a bearing on some other places also. Another matter is being filed before your Lordships, my Lords, same issue.
Is being filed or has been filed?
It's in the process of being filed, my Lords, same issue. But of course, from another area.
Shella?
Well, it's...
Because there was another petition that day regarding that Shella land custom station.
This is not Shella, my Lords, this is some other area, my Lords, I don't recollect.
Okay.
I'm the main.
On the prayer, Mr. K. Paul, National Council. This is matter also.
Lordship.
Yes.
Oblige, Your Lordship.
The dates will be given by the court master.
Main list, item number 1. Main list, item number 1.
I pray for further 1 week time to complete instruction, Lordship. One week, Lordship.
What instructions? Only some queries.
Yes, Your
asked by
Lordship.
the, what are
Yes,
the queries asked by the court?
Your Lordship, the petitioner was sick, so I could not talk to him nicely.
No,
so
no. What
he's
are the
coming
queries?
on
Do
Monday.
you remember what are the queries put by the court?
Lordship,
What are the queries?
I could not consult with the.
No, what are the queries put by the court?
Lordship, I agree, Lordship. I could
What,
not consult.
what were the queries? I forgot because the court's
With
forgotten.
the queries was,
Because
Lordship.
it shows in the order that praising be allowed to obtain instruction or queries put by the court.
There
But the
are-
court has forgotten what queries because it's yes.
Two queries,
queries?
main
Yes.
queries is that why there is a delay in filing this petition and why I have not applied for the probate.
Why I have not applied for a probate?
Yes, Lordship.
Yes.
So
So
they-
why you not apply for the probate?
So, Lordship, I pray for further 1 week time, Lordship, because Lordship, the petition is coming on a Monday, and
Okay. No, at least I remember what queries put.
Yes.
Yes. Mr. B. Depp prays funds allowed 1 week for the time to obtain instructions on the queries put by the court. Yes. Delay and why no probate was filed.
Lordship, yes, Lordship.
Supplementary list, item number 1.
Yes, Mr. Nobody.
Yes, my lord. My lord, this morning I got a request from a certain officer from the department requesting me to not press this matter for today. Let it come after a week. They will
My
try
lord,
and.
if I may submit, this is a second round litigation, my lord. Lordship is directed on the month of November that a fresh agreement has to be drawn on submission made by the counsel. A fresh agreement can be drawn, my lord.
Okay.
It was on submission made by the respondent, my lord. That has not been done, my lord.
Why has that been done?
My lord, what I have been informed is that the first portion, that is release of the salary, that has been cleared. The second portion was drawing a new agreement, my lord. In that issue, my lord, we have to look into the aspect, because what happened, my lord, after the order was passed, there were certain demand that has fallen upon us, my lord, like asking for arrears and the agreement to be drawn from a day that he was removed from service. Those issue has come up, due to which, my lord, we were not able to draw a new agreement. So in this regard, my lord, we require to take instruction on this. How? So, my lord, may kindly give us some more time on this.
Mr. Goldie prays for will issue notice.
My lord, like
Yes,
submit
Mr. P.
Lordship,
Yes, Mr.
if
Sai.
I may only submit, Lordship, the petition otherwise would not be maintainable because it's a writ petition on the same cause of action.
Two counsels
But
appearing,
since the parties are working something,
Tag team.
Lordship may
Yeah,
simply
together,
defer it to not issue notice. Because the allegation in the writ
Will
petition
issue
is
you
that
make your
Lordship's,
objections in due
previous
course. Yes, heard Mr. Philanobri, counsel for the petitioner issue notice. And Ms. Arkoni and Ms. S. Sahai and Ms. Arkoni are present on behalf of
all the
the
respondents.
respondents. No further call for list after.
In the meantime, my lord.
List after 4 weeks.
In the meantime, my lord, the quarter.
Stop. No, to stop. Yes. Counsel for the respondents is directed to obtain specific instructions before the next date.
Item
My
number
lord,
2.
in the meantime, I should not be evicted from my quarter, my lord.
They will not do anything.
Deeply, Your Lordship.
Item number 2.
In person, Mr. Zareka. Then you kindly, if you have to remove, you have to go outside at least and, attire yourself properly. Just call it the other matter first. You just go and attire yourself, make attire.
3.
Here, my lord, I'm challenging the constitution of SMC Lordship. That is at page 35, Lordship.
Page?
Page 35. Here in this case, the government in their pair has already admitted that it was not as per the rules, Lordship.
35?
35, Lordship. Type copy. That is the in-pin order, Lordship.
Yes, what do you agree with?
The constitution was made as per Rule 13 for a period of 1 year, Lordship. And what does Rule 13 of the Right to Education Act says, Lordship? That is at page 20, Lordship. sorry, 21, Lordship. 21, Lordship.
Yes.
Page 21. Rule 13, Lordship.
Yes.
Here, para 2, Lordship. Rule 13, para 2 says that 75% of the strength of the SMC shall be from among the parent and guardian of children studying in the school. But in the Indian order, Lordship, only 2 are parent and guardian, the rest are non-parent and guardian, Lordship. And that has been considered by the state respondent, Lordship. So moreover, the term of the managing committee is 2 years. But here, even for the term also, they have violated the rules, yes, Lordship.
Yes. So what do you want now?
Now, my lord, for fresh direction, Lordship, that is para affidavit in opposition, page number 4, Lordship, filed by the government.
By respondent number 4?
Yes, Lordship.
What do you say?
Para 9, sub para down, Lordship. It's considered, Lordship, that it was not as per the rules, Lordship.
Para?
Para 9, sub para down, below down, Lordship. In this regard, it is further mentioned that none of the names.
Yes. Right. Anything you see, Mr. Hassan?
Yes, my lord. My lord, managing committee was constituted the ad hoc managing committee because of the conducive situation arise at the school, 2 rival parties. That is why the school was running without managing committee for almost about 16-17 months. The headmaster is facing serious difficulties in withdrawing salary and running the school administration. Therefore, finding no alternative, the respondent number 4 issued the interim order giving for ad hoc managing committee only for an interim period to run the school matter. So in near future they can conduct parent guardian meeting. This is the background of this.
So is direct the DSEO to conduct a parent guardian meeting within 2 weeks?
Yes.
A reasonable time may be given to conduct.
Yes, sir.
If there are rival parties are there.
Rival parties always be there. If there are no rival parties, why having no managing committee?
His position will not be changed, Lordship, since he is the headmaster. He automatically he will be the ex officio.
Yes. Heard Mr. S.K. Sheikh, then council petitioner. Mr. K.B. Bhattacharya in behalf of the respondents and Mr. S.K. Hassan for the respondent number 5. Stop headmaster. The challenge in the incident petition is to the notification, is to the order
29 July, Lordship.
dated. Where is that?
That is
22.
29.
This is 22 matter.
Yes, Lordship. Yes.
Yes, dated 29 July 2022, whereby the sub-divisional school education officer, Dadangre, approved the constitution of the ad hoc management committee of Bajbari Deficit UP Madrasa School, New Bajbari under Dadangre subdivision, West Garo Hills. Stop. The constitution of the ad hoc management committee was purportedly made under section 13, under the Meghalaya right of children to free and compulsory education rules. Stop. Next para, Mr. S.K. Sheikh, his submissions. Mr. S. Sheikh has submitted that the ad hoc management committee has been constituted in direct violation of section 13 of the said rules and has drawn the attention of the court to the said provision. So, it's a provision which provides that 75% of the strength of the school management committee shall be from amongst parents or guardians of children studying in the school. Stop. He submits that this not being the position, which has also been confirmed by the affidavit of the state government, the ad hoc managing committee has been made on the basis and has been illegally constituted, and the approval has been illegally constituted, and as such should be interfered with by this court. Stop. Next paragraph. Mr. K.V. Barasaji, Learned Counsel, Learned State, Learned GA, does not dispute this position and submits that. What's your submission? Perhaps the approval has been obtained by misleading the said issuing authority. Stop. By Mr. S.K. Hassan, appearing for the headmaster, respondent number 5, submits that the constitution of the impugned managing committee was occasioned due to the fact that the said school was without a managing committee for 16 to 17 months, which had caused severe hardships in disbursing the salaries of the teachers and in the functioning of the school. Stop. He therefore submits that if the impugned constitution is interfered with, reasonable time be given to convene the parent-teachers meeting for reconstitution of the fresh managing committee. Stop. Having heard the counsel for the parties, it is noticed that section rule 13(2) of the rules, Archival rules, provides as follows: rule management so and so. Stop. It is also noted that the state respondents in their affidavit, specifically at para 9, sub-para, have conceded this position, which for easy reference is reproduced here and below. Considering the matter in entirety, it is directed that the sub-divisional school education officer, he will be authority to convene the meeting, correct?
Yes.
Shall, within 4 weeks from today, convene a meeting of the parents and guardians of the said school, so and so, for selection of persons for constitution of new bank committee as per the rules, as per the said rule. Stop. Next, accordingly, the impugned order dated 29 July 2022 is set aside and quashed. In the interim, the administration of the schools have been looked after by the respondent number 4 till the said constitution. Writ petition stands allowed and disposed of. Yes.
Item number 2.
Yes. What happened, Mr. Hazarika? Why are you coming in person?
Only for that reason, I have submitted two representation to SP and the DGP, Director General of Police, in respect of stolen property recovered by the police, and even from police station it was missing, not registered in the police station, not even sent to the Chief Judicial Magistrate, Thura, my lord.
What stolen property?
Stolen, there is number of properties, only one.
Your property?
Yes, my lord.
Let's see what. Why are you coming? Why are you before this court then? Upper directions wanted to dispose of patient dated, sir. What recovered? Let's see. Okay. Where is that?
There is 2 times, my lord. One is
2 times your house was burgled.
Yes.
What kind of place is staying in where same house gets burgled twice?
I do not know. No,
because you're in Shillong all the time.
No,
so it's empty house.
No. In fact, my lord, that is out of my argument. There is political angle is involved here.
Political angle in burgling a house?
No, for doing this act, my lord. Even when the police interrogated.
Do you think there can be vandalism or it can be a case of theft and burglary?
No, because they are taking advantage because I am not there.
The house is empty.
Empty. Now I am taking the caretaker.
How can you just make this kind of, the saying that because of political angle that?
No, because they have arrested, because I have given some suspect, they have arrested. After that, recovered this property, and they have admitted the fact. In the meanwhile, I was in the police station. This SP is called the police.
Is called the police?
No, they have called from by phone. They are innocent. You have to release them. One of the sub-inspector from the police station informed me, because we have to obey the higher authority. For law concerned, you try it. That is the matter, my lord. Then I have submitted the representative to the SP, not taking any action. Then I filed the representation to the Director General of Police to take action as per my statement given in the representation. Only my limited prayer, my lord.
What were the stolen properties?
This stabilizer recovered and other property could not be recovered, my lord. Electricity, then my inverter, then batteries, and so many clothes also, even TV also they have taken. All this.
So you didn't give FIR in the list of all the stolen properties?
Yes, I have.
Where is that?
Yes, FIR I am coming.
Let's see.
First FIR on page number 19, my lord. Type copy on 21, my lord.
How far from Tura is this place?
Place is 100 kilometers.
From Tura?
Yes, my lord. 98, of course.
This, okay. So they stripped they tore all the wires also?
Yes, because with this some other instrument, that also it is there. Then another FIR I have filed on 6 May 2019, my lord.
19? When was this FIR filed? 2014?
Yes, my lord. They have not taken any action.
Mr. Hazarika, how do you expect the court to take cognizance of a case which is nearly 10 years old?
Even I have filed this FIR against this OC also, my lord, to the SP, not taking any action. Only I want that a simple one, that my representation to be disposed of within period of 1 month and with an intimation to me, my lord.
What have happened to those accused persons?
Accused person was released. They have not.
It ended in FR.
Yes.
What happened to the case?
And then they have submitted a FR.
Submitted FR. You objected to that.
Then I objected it.
Then investigation is still going on.
Yes, investigation
for 9 years.
Yes. They have recently filed, my lord, FR. Because IO was transferred after that law. They have not taken any action on this.
Then considering the fact that you're practicing lawyer in this court, the court just will give you some.
No, I hear, my lord, some relief. I come for some relief only for some disposal of my representation, not in the criminal matter, my lord.
Okay, heard Mr. Jazreka. Yes, Mr. Sheikh, what do you have to say?
So far as that case in 2014, lordship, the police has submitted the FR due to insufficiency of evidence, lordship. Then he objected, then the magistrate has directed for the investigation, and during the course of investigation the IO has issued notice to the suspect, lordship, and the statement of the petitioner also yet to be recorded, lordship. So since he is not available that side,
not recorded till now?
Yes, lordship. They have not recorded. They have called me. I went there. That IO of this new IO is not present in the police station.
Lordship, we don't know about that.
Yes, maintainability, lordship. Maintainability, my lord, if he is not satisfied with the progress of the investigation or the manner in which the investigation is carried out, the remedy is otherwise, lordship. So, my lord...
Remedy is there, sir.
Yes, lordship. So, my lord, that the petitioner
cannot... The presence of what remedy?
The writ jurisdiction, Lordship.
No, court is only sympathetic because he's a lawyer practicing this court as well. There's no other consideration. There's no other legal consideration. No other consideration. So Mr. Hazarika appears all the time. At least
I leave it only for representation, my lord.
that's what. There's no consideration.
Yes, my lord.
But just remain within the
representation. But at least my submission.
Yes, of course. Mr. Zareka, who is an advocate of this court, is appearing as petitioner in person by way of the instanted petition with a prayer that a representation which has been filed since
2014.
2014.
Representation will file on 2019, my lord.
It's been filed since 2019.
31st 5, 2019.
It has not been attended to.
And another one.
Has not been attended to by the authorities concerned. Stop. The background facts of the case is that the advocate's house has been burgled on 2 occasions.
Yes.
That is in the year 2014 and
19, my lord.
19 May 2014 and
yes, here is date I am telling, my lord, 20 June 2014.
On 20th June 2014
and another one is 6 May 2019, my lord.
And again on 6 May 2019. And that in the said burglary, valuable household articles and electrical items have been stolen. Stop. Thom I'm sure Kata in the background facts, yes. Has been burgled twice. Once in 2014 and again 2019. So apart electrical wires. Yes, stop. The case of the petitioner is that the concerned authorities, police authorities, do not attach much importance to the case, nor were the recovered stolen items given in Zimma to him. Stop. His only limited prayer, as per submissions, is for directions that his representation be disposed of. Stop. Next paragraph, Mr. S.A. Sheikh, learned PP, oh, I'm sorry, GA, appearing for the GA, submits that firstly, the incident first took place in 2014 and again in 19. And as such, the 19, which makes the writ petition non-maintainable for various reasons. Firstly, the delay. Secondly, is the fact that an FR was returned in the said investigation, which on objection by the petitioner, re-investigation has been directed by the Chief Judicial Magistrate. Stop. He also further submits that the accused in the said case have been re-examined.
No, Lordship.
They have been issued notice.
The suspects.
The suspects have been issued notice, but the petitioner is yet to give a statement till date. So he submits that there being no ground for, even no cogent grounds for any interference, the petition deserves no consideration. That's submission, correct?
And because maintainability with regard to, because he should have approached to the concerned
Oh
magistrate.
yes, maintainability of delay and availability of alternate relief. Yes. Next. We have further concept of the parties. Stop is correct as per submission Ms. S.E. Sheikh that the maintainability of the writ petition is questionable, and in fact the writ petitioner has recourse to other alter remedy under the CRPC for inaction of authorities in such matters. Further looking into the before further looking into what I see before that. On inaction of this. However, in view of the limited prayer of the petitioner, which respondent is this?
Yes.
Supreme Police.
Yes, respondent number 2 and 3, my lord.
Respondent number 3 is directed to look into the matter and in the process dispose of representation of the writ petitioner within a period of 6 weeks from the date a copy of this order is presented before him. So, matter stands allowed to the extent indicated above is disposed of. Just because you're
Item number 4.
Yes.
I am now faced with an order passed by the learned ADJ Emirates. So, insofar as this matter is concerned, Emirates, of course, with the earlier order passed by Lordships, this becomes infructuous.
You take recourse to.
I would have to, Emirates.
Yes.
I think that order has been placed before your Lordships.
Yes, Mr. Paul and Senior Counsel has referred to order dated 8/5/2023, whereby the injunction matter has been finally adjudicated. Therefore, please allow to withdraw the application. This matter will be closed as been rendered infructuous.
Emirates.
Yes. Accordingly, in which counsel is present on behalf of so you submission to the Senior Counsel, matter stands closed. Yes.
Emirates.
And disposed of. Yes.
5.
What is this?
Tender matter.
Contempt matter?
Tender matter.
Yes.
Tender.
What instructions do you have, Dr. Mojika?
Lordship, I submitted on the last date, and that my prayer is that due to the infirmities.
No. I mean, we already called for instructions.
Yes.
I already heard you on your on the motion day. Yes, Mr. Dr. Mojika.
But I have received instructions on it. But the matter is at technical scrutiny, my lord. Now, 4 participants are there. 4 bidders were there. Participate in the process, my lord.
What is this? What is the name of your?
Contact.
What is the name of your concern? Your part. What?
Samrat Inder Singh.
Samrat Inder Singh. Okay, you're number 2.
They are aggrieved by inclusion of OSS Enterprise, my lord. They are aggrieved because we technically qualified OSS Enterprise, my lord, who is a private respondent here.
Okay.
And the ground which for this is, my lord, that OSS Enterprise did not submit some documents, my lord. And the relevant documents are as per clause 6 of the tender document, my lord. I'll just point out. Page 23, my lord. Page 23, clause E, my lord. This is
existing contracts and tender participation.
Details of existing contracts and tender participation. Bidders will submit details of existing contracts for the financial year 22-23 and tender participation for the year financial year 23-24 along with values of the same failing which bids tenders are liable to be rejected. Value of financial stability certificate will correspondingly reduce the subsequent tenders. The bidder will be eligible to participate in the tender equal to the value of the financial standing certificate provided at the time of tendering. In the event of non-participation in the tenders of FY 23-24, details can also be submitted as nil, no participation in any tender for FY 23-24.
Yes.
My lord, what the instructions say, my lord?
What does the instruction say?
Clause para 3 of these instructions, my lord, and there's firstly they have quoted provisions of 6E, my lord, 6E and F. Then it says, well, as per the subject clause, the bidders were required to provide details of all ongoing contracts and contracts for which they had participated in the current financial year so as to calculate the financial limit up to which they could participate subject to their financial capacity. However, Messrs. Oasis Enterprise, while submitting their bid, did not submit the requisite details. The petitioner, Mr. Samrat Inder Singh, by his complaint dated 9 December 22, raised this objection upon which a detailed deliberation was carried out at this headquarters. During the course of this deliberation, it was decided to ask the requisite details from Mrs. Oasis Enterprises. Consequently, the firm Mrs. Oasis Enterprises provided the details of current contracts but did not provide the number of tenders in which the firm had participated. Upon the receipt of the details, a decision was taken that the same did not have any material impact on the execution of tenders, and hence the firm's Mrs. Oasis Enterprise was found valid to take part in the tender.
So what do you have to say? Your name, please?
Lordship, my name is Shoman Chaudhary.
Yes, Mr. Chaudhary.
My lord, if we read the paragraph 3, everything we have submitted has been admitted in toto. And in the last, in paragraph 5, it has been that upon receipt of the details, a decision was taken that the same did not have any material impact on the execution of tenders, and hence the firms of Messrs. Oasis Enterprises was found valid to take part in the tender. That is without any reason. Why? It is that it is of no material value. While the tender document in 6E clearly demonstrates details of existing contracts and tender participation. Bidders will submit details of existing contracts for the financial years 2020 to 23 and tender participations. It is tender participations for the year 2023-24 along with the values of the same, failing which
the bid be rejected. Yes.
Yes.
What
kind of tender committee is this? They can waive the conditions given by the.
Malad, in my humble submission, some conditions in tender are essential conditions, Malad, which affect the very eligibility.
Okay, fine. Then where is that? That saving clause that you have in your own tender document. That's something which doesn't materially affect the contract or the execution of tender. Then it can be overlooked, or it can be condoned, or can be relaxed. Where is that? If you can show that is well within the power of the tender committee to relax this requirement, well and good.
My lord, in my humble submission, even without such a specific clause, my lord, all tender conditions are not essential conditions, my lord.
How do you say that?
There are case laws to that effect also.
You see, Mr. Dr. Muzika.
It says,
read the clause. Bidders will submit details of existing contracts for the financial year 22-23 and tender participation for the financial year 23-24, along with value of the same failing which bidders' tenders are liable to be rejected. That means first requirement is to show how many tenders you participated in. That's the essential one. Right. Then the qualifying one may be, add a value. So, and what have you done? What has that respondent done?
The current contract.
It has given the current contract a number of tenders which a firm participated, which is very essential. See the number of tenders which a firm participated. Is there a ceiling on how many tenders a firm can participate?
But because ceiling only to the extent, my lord, to assess the financial stability, my lord. if somebody has a financial capacity of 1 crore rupees, my lord, and if he participates in 10 tenders of 1 crore each,
then how will that person be able to service all those contracts? Then that is the consideration why this clause has been put. That when he can't just file, just like tender contracts. Apply for submit his tender for 100 contracts.
My lord, what I would pray, my lord, this is a technical bid stage only now, my lord.
When is the contract for which period? The supply contract, correct?
Yes, sir.
It commences from when? As per a tender, it will commence from when?
It was the opening date was originally.
No, it commence from when? When suppose you settle with the contract, when do you have to commence your operations?
The date on which it is awarded.
Now who's doing the supply? This is food items.
Yes, I am. Is
You're the existing supplier. Okay.
It says that the contract when awarded will remain operative up to 31st March 24.
Now he's continuing.
My lord, it is absolutely that the bidder, the value of financial stability certificate will correspondingly reduce the subsequent tenders. That is why it is essential. In 6E.
Oh, no, forget 6E for the time being.
What are the at this stage?
You file affidavit. No further.
1 week's time I'll file.
No further action on the tender process shall be stopped for today. Yes, sir. Third, Mr.
What is the difficulty?
See, there should not be any break in supply to the troops as well. That's the only thing.
But since there is a continuing contractor, my lord, the intentions, my lord, it appears, my lord, is delaying the tender process, my lord, so that he remains in the contract, my lord.
Naturally, why shouldn't you delay it? Because if it's a faulty acceptance of the other bidders, then he stands to gain. He's not gaining because of his own deficiency. It's because of your deficiency. They call it windfall.
But the conclusion of the tender committee is that it will not materially affect the execution.
It doesn't matter. If it's a tender condition, you come out with affidavit with disposal of within today's 12th.
My lord, or else, my lord, if lordship permit us to proceed with, not to finalize the contract, my lord, till the matter is decided. It is that also takes some time, my lord.
Heard, Mr. What is your full name?
Showman Chaudhary.
Mr. S. Chaudhary, another counsel petitioner, so and so stop. The petitioner is aggrieved with the acceptance of the tender documents of the respondent number 3, inasmuch as the requirements as per clause 6E of the tender document has not been complied with or fulfilled and complied with. Stop. Which order we asked for instructions? Which order was instructions called for? Or by order dated, next paragraph.
9-5.
By order dated 5-5. By order 5-5, this court had directed for instructions to be produced by the learned DJCI on behalf of the respondents number
1 and 2.
1 and 2. Stop. A copy of the said instructions dated 11 May 2023 has been produced today. And it appears that the tender of the respondent number 3 was accepted as valid by the respondents on the consideration that though the entire details as stipulated were not submitted, however, the same would not have any material impact on execution of tenders. Stop. Next paragraph. Dr. M. Mozika, learned counsel of the petitioner, submits that the tender committee, on consideration of the bid of the respondent number 3, and having come to a decision that the non-submission of the other requirement, that is the number of tenders in which the firm had participated. No? Boleh. Number 3, what? Which the firm participated had no material impact on the execution of tenders, and as such, the bid was accepted. Ms. S. Chaudhary, however, has raised vehement objections that the condition as contained in the tender document is of vital importance, and a non-observance thereof, as provided in clause 6E, held the respondent liable for rejection of tender. Next paragraph. As a prima facie case was made out by the petitioner, it is directed that the respondent is directed to file the affidavit within
1 week.
Within 1 week from today. What about respondent number 3? Notice issued?
No.
Within 1 week from today. Notice also issued respondent number 3, both by said AD into Dusty service. But stop. Next one is provided that until the next date, no further action should be. There should be no further progress in the. There should be no further action on the tender process, undergoing tender process. Stop. This also.
Since the private is funding also, the pay for 10 days time.
10 days time. Yes.
Obligers.
Item number 2, main list. Main list, item number 2.
Yes, Mr. Kumar.
Item number 2 and 3. Item number 2 and 3 both are identical matter, my lord. And affidavit in opposition has not yet filed, my lord. Notice was issued on 18th November.
File affidavit, at least. SLP is pending. Are you party there? Mr. Kumar, are you party in the SLP for the Supreme Court? Your party?
Yes, my lord. Yes, my lord. Yes, my lord.
So let them file affidavit then. Give them some time. Yes, sir. Further 3 weeks time granted to the respondents to file affidavit. Yes.
Deeply. 2 and 3.
4.
My lord. Be clear, your lordship.
Item number 4.
Please, Lordship.
Yes.
We have taken the steps. The service report is still awaited, Lordship.
The phone file has been received now. Been received. Yes, the officer indicates that service on respondent 4 and 5 has been complete, but no appearance has been made on their behalf today. Stop. Yes.
You filed the affidavit.
You already filed the affidavit. Mr. SD, SDEP, sorry, appear on behalf of respondent 1 to 3 submits that the affidavit has been filed. This is matter after so and so to enable appearance of the respondents 4 and 5. Okay.
Lordship allow us to take Dusty steps.
Yes.
Lordship. Dusty. If
No, already received.
5.
Yeah.
Please, Your Lordship.
Yes.
Your Lordship, as per the direction, I filed the affidavit bringing on record the notice has been completed to all on respondent number 5 and 6.
Who's appearing on their behalf?
I have verbal instructions to appear on behalf of 5 and 6. I'll file Wakalat.
5 and 6 is? Okay. Mr. KZ Gautam, affidavit of service has since been filed by the by the petitioner bring record the status report the status of service upon the response 5 and 6. Stop. Next line, Mr. K.C. Gautam has is present today and submits that he'll be entering appearance on their behalf. What about the other respondents?
Respondent 4 have been duly served. AD
Who's
is also
appearing for number
duly
4?
served.
4, 5 and 6. Or then Mrs. 4, 5 and 6. As such, service complete. This is matter after 4 weeks for affidavits by the private respondents.
Your Lordship.
And for further affidavit, you have not filed affidavit.
I have not filed one. I'm
And for the affidavit by the respondent number?
1.
1, yes.
Your Lordship, at this stage I'm praying that their operation may be stayed. As such, they have entered appearance.
What kind of prayer are you making? It's an appointment. Read up, and then you make this kind of prayer. 4 weeks, Your Lordship. Already over 1 year, people have been working.
Yes, Your Lordship, but now they have entered appearance. So
you mean to say that who will go in their place?
Sorry,
You disrupt the entire judicial process.
No, Your Lordship.
Then is that what you intend?
No, Your Lordship.
Is a dog and a manger attitude?
No,
You know the dog and a manger. You read about it. It's called dog and a manger. M-E-N-G-R. You see, you won't let others sleep, and it's not your place to sleep also.
No, Your Lordship. I'm not having that.
So like that. Anyway, let them file affidavit.
My lord, opportunity was provided for the respondent number 6 to appear, but no appeals. Otherwise, pleading is complete.
Number 6 was appearing. 1, 2, 4, 5. Number 6 is whom, Mr. Pandit?
Respondent number, private respondent C is
also important respondent.
Your Lordship, C also claimed to be wife of the TC.
What are those unfortunate cases?
Your Lordship, I'm appearing on behalf of respondent number 5.
Number 5. And who are you?
Wife. C is also claimed. I'm the also wife.
He has 3 wives, the deceased employee.
3 wives.
And who's getting the benefits now?
The state respondents, they have agreed to settle the family pension in favor of respondent number 5.
Then she's the you file affidavit.
They have filed. I'm the eldest.
Eldest meaning?
Eldest widow of the deceased. But they have declared respondent number 5 as the eldest widow. Based on a marriage certificate, which was the marriage certificate that is also invalid in the sense that the marriage certificate, the date of registration.
Does not for this court look into.
Yes. But prima facie, Your Lordship, that marriage certificate is not tenable in law.
See, Mr. Pandit.
When the petitioner was, when the deceased was 10 years old, that time the marriage was took place as per their marriage certificate.
As per the marriage certificate, yes.
When the deceased was 10 years old.
Yes, as per the marriage certificate, they are saying that marriage was solemnized in 1972, but that time he was 10 years old.
Date of birth is 1962 of the disease. Date of birth of the disease is
If we go as per the marriage certificate.
He has a registered birth certificate.
No, Your Lordship,
See, birth certificate can not mean anything also.
As per the official record also, service record, birth certificate.
I mean, as per the entry in the service book.
Yes.
He's born in 62.
62.
He got married in 72.
Yes, because respondent number 5 is submitted.
And I have been living since 1989. I have 9 children out of
9 children.
Yes. 1989. I have
Very prolific fellow. Anyway.
Yes.
We listen for hearing.
Yes, sir.
Yes, as none appears for respondent number 6, despite of service of notice, the matter shall proceed ex parte against the said respondent. Stop. Mr. S. Pandit prays the matter be listed for hearing. Yes. According to this list the matter for hearing, in usual course.
7.
Please, Your Lordship, we are supposed to file a rejoinder affidavit.
Yes.
Kindly grant us 1 week time, Your Lordship.
Your name?
Ms. D. Khongwir.
D?
Khongwir.
Khongwir. With your Mr. Harsad.
Harsad.
Respondent number 4 and 6.
You filed. You already filed affidavit.
Yes, sir.
And Civil Council not filing. Okay, MS Khongwir pays funds allowed further 2 weeks time to file rejoinder to the affidavit filed by respondent number 4 and 6. Yes, accordingly and so on.
8.
I filed the affidavit, Lordship, on behalf of the respondent.
Yes.
We are not filing in rejoinder.
Mr.
Arif account. A account.
Aircom, yes. Mr. Aircom submits the no rejoinder without coming to the affidavit of the respondents. Accordingly, this is a matter for hearing. We will pause and so on.
9.
Your Lordship, I plead for further 2 weeks' time to file my rejoinder.
How many times have you taken?
This will be my
Nasang
second.
lawyer?
This will be my second, Your Lordship.
Okay. Mr. Ilasang lawyer, please for further 2 weeks' time to file rejoinder affidavit. This is thereafter and so on. So.
10.
Election matter.
Yes?
Election petition, Lordship.
Okay. You file your Hazira?
Yes, sir.
Yes. 1 and 2 is Mr. Sangreso. And number 3 is?
Lordship, I'm appearing for respondent number 3, Lordship.
Today only.
Lordship, I've already filed my Hajira also, Lordship.
Yes. How much time you want for this statement?
Lordship, I just want to file some objections on maintainability, Lordship. Allow me 2 weeks' time, Lordship, on this.
You can file on maintainability, which is substantive maintainability, or it'll come in with a written statement.
That is only for this maintainability, some objections because the allegations that they have made, Lordship. So
No, what do you mean allegations?
action, with the cause of actions and all, with all that they're saying with the subsisting
Are
contract.
you filing application under Order 6/16, or what kind of application are you seeking to file?
I will be filing if Lordship allows me, Lordship, an order 7.
No, allow you, provided you know what kind of application you're filing. For striking out the pleadings.
Lordship.
Are you filing an application to strike out the pleadings made in the election petition?
Lordship, there are some.
No, you're saying there's some things made there which the pleading is not correct. Correct?
Yes, Lordship.
Yeah, so are you filing striking out pleadings, or you want to file to challenge it, or you want issue to be framed to challenge maintainability on a certain point?
On maintainability, on certain
Then that has to
points.
come, striking out pleadings and maintainability will be two different aspects.
Lordship,
You decide.
Lordship, allow me only 2 weeks.
Strike out
Lordship,
pleadings.
and
You attend appearance today?
yes, Lordship.
MS petitioner is present, MS file 0. MS S. Appearance on behalf. Respondent 1 and 2 also are present. To Mr. H.L. Sangreso and Mr. P. N. Nongbri. Respondent number 3 is under appearance today and filed attendance. File Hazira through MS S.K. Nongrum. Stop. Mr. S.K. Nongrum prays that he may be allowed 2 weeks' time to file appropriate application for striking out pleadings of election petition. Stop. Prayers allowed. List after 2 weeks, yes.
Obliged.
Yes.
11.
How do you manage account from Impal?
Yeah, my lord, actually,
No
I
problem.
came, I came yesterday.
Right.
But there is no internet connection. I could not even attend in the VC also. That's the problem. I have to come physically.
No, I mean, yes.
Yes, ma'am.
Is everything been served?
Yes, Lordship.
I'm appearing for respondent number 3, Your Lordship. My entering appearance.
You're the return candidate.
No, Your Lordship. One of the contesting candidates.
I'm for respondent number 1.
Who the return candidate?
And respondent number 1.
Yes, Mr. Sai. Anything to say?
Lordship, I appear with Ms. Nongrum for respondent number 1, who is the return candidate.
Okay. You are appearing
Lordship,
for?
in this, we'll be.
Yes?
We'll be filing an application if Lordship permits under Order 7, Rule 11, read with.
For return of plane.
Okay.
Right?
Yes.
You can,
rejection of
whatever, yes.
Yes, yes.
Yes, Tito Star. Yes. Mr. Enju Tandro Singh, the senior counsel with your Mr. is present on behalf of the election petitioner. Stop. Mr. S. Sahai, together with MS S.K. Nongrum, has an appearance today on behalf of the respondent number 1. And they pray that they may be allowed to file an application under Order 7, Rule 11 of the CPC. Stop. MS is is present and enter appears on behalf of respondent number
3, Your Lordship.
3, and you? Where's your Hazira? You file it, huh? And so is written about to number 4. Stop. As per the prayer of the respondent number 1. How much time do you require? 2 weeks time is granted for filing of the appropriate application.
That is on 26, I think. Also on 26.
26 of Friday. 26 of May. This court won't be available.
Yeah.
You have to take it till June.
Yes, my lord. Then at firm date may kindly be fixed.
Yes, then finally firm date we'll have it on the 14th of June.
14th of June.
14th of June. This is matter 14th of June. Yes.
Yes, my lord.
Highly obliged.
12.
May I please, Lordship?
Yes, Mr.
Lordship, I prefer some more time to file my affidavit in this matter.
Let him file the affidavit, Your Lordship.
You allow them. Okay. 6, 7, 9, and 10. And MSS Lalu.
Lordship is with me, Lord.
Okay. How much time? 2 weeks first time granted the respondents, state respondent and para respondent to file respective affidavits. This thereafter.
13.
Item number 13 to 16 are identical matters.
4 months.
Against the corporation for release of may I just pray for additional 10 days, my lords, to obtain instructions.
4 to
13 to 16.
4 to. How many have you done?
It was item number 13 to item number 16.
4. Sorry. Okay. Item 13, 14, 15, 16. 13 to 16. Yes.
13 to 16.
Mr. SN prays for further 10 days time to obtain instructions. This thereafter.
Highly obliged.
13 to 16, huh?
17.
My lord, item 17 up to item 31 are all connected, my lord. Now, on some of the matters, the affidavit have been filed. Item 17, the pleadings
What
are
is
complete.
the matter about?
My lord, the extension of fifth pay benefit, my lord, to work charge employees. In terms of the rules, my lord, the provision of pay rules.
So, Your Lordship, I may be allowed to submit item number 17, 19, 20, 22, 31, and 26 affidavits are filed.
You do one thing, you kindly give the reparation numbers.
Yes, I'll provide it.
I have filed the affidavit.
No, you kindly give the reparation numbers to the
Yes,
court master.
We'll do that.
Yes, MS Parachai submits that in WPC's so absence been filed. Stop.
And what are not filed, Your Lordship?
And the ones that have been filed where? And after it's pending in WPC number?
Item number 21.
WPC 507, my lord. 509.
Just give the list.
Yes, sir.
Where you file and where you not file.
Yes, sir.
Yes. How much further time? 2 weeks further, 3 weeks further time granted to the respondent to file the remaining affidavits.
In item number 31, I am appealing for the petitioners.
Number 31.
It is in shared list, but connected. It will be connected.
Same issue.
Yeah, no, it'll come the same list.
Yes. Deeply obliged.
Supplementary list. Hearing. Item 7.
Just give me 5 minutes, Mr. Sen. Petition and affidavit. No, my lord. And this is a case, my lord. In fact, I have made substantial submissions, my lord, how the relevant provision of the EGC regulation 2010 adopted by the government of Meghalaya is binding of the state government, my lords. Now, here the issue is, my lord, pertaining to, my lord, granting of increment, what is called promotional increment, because admittedly, my lord, we are all, there are 3 writ petitioners. All the 3 writ petitioners, writ petitioner number 1, she is serving, at a relevant point, she was serving as assistant professor in Shillong College. And 2 and 3, my lord, they are still assistant professor in Senate College. Admitted position, all these colleges, both the colleges are, my lord, deficit, under deficit system, and they are holding sanctioned posts. So, my lord, after government of Meghalaya, my lord, adopted the UGC regulations. Under the UGC regulations, my lord, 2010, they introduced 2 pay band. 1 pay band for, my lord, associate professor and above, and 1 pay band, my lord, for assistant professor, with, my lord, multiple opportunity to move along, my lord, multiple opportunities for, my lord, moving from one academic grade to another academic grade. The initial level, my lord, for the assistant professor, the academic grade, was AGP was of 6,000, my lord, the initial entry. Now, thereafter, my lord, on fulfilling certain conditions, my lord, and completing certain period, they were eligible to move to the next higher grade, AGP, that is 7,000. Then again, my lord, from 7,000 to 8,000. Now, my lord, I had made my detailed submission. I will not repeat on those. Now, the rules very clearly, categorically, that scheme of, my lord, 8 December, my lord, 2008, my lord. What is that scheme? That scheme of, my lord, 31st December, I'm sorry, 2008, my lord, clearly, categorically provide, my lord. Yes. Scheme of
7922.
Yes, Mr. Sen.
Clearly and categorically provides, my lord, I have, lordship has already noted down, my lord, clearly categorically provides, my lords, for each placement,
yes,
for placement in each, my lord, academic grade, my lord, higher grade, would carry carry increments. Now, what would be the increment, how it will be decided, my lord? It is also provided, my lord, it comes under, my lord, the pay fixation. So far the pay fixation is concerned, my lord, where the increment is to be incorporated, then they say this is as per the decision taken by the central government. Now, so far the central government is concerned, my lord, after the 6th pay commission, my lord, they have notified what, they have made a rules, my lord, what is called, my lord, Central Civil Service Pay Revision Rules. Pay revision rules, my lords, and there I have, my lord, annexed, my lord, the relevant provision, how it is to be fixed on promotions. How it is to be fixed, my lord. Now, my lord, strangely, your lordships, so for writ petitioner number 1 is concerned, my lord, she was moved to the academic grade. That table I have set out, your lordships. Table is at page 16, my lord, of the writ petition.
Oh, yes, yes. Samantha, we pledge Babada Malay at the Athlete National Ajala. Nice that Alashu shall be. Ajala Talabroshi seat in thought. Yes,
page 16, your lordship. Now, writ petitioner number 1, my lord. Writ petitioner number who joined in 1/8/2005, my lord. The first stage, my lord, from stage 1 to stage 2, lordship, there is 6,000 to 7,000, my lord, AGP. She was, my lord, moved to the highest stage, stage 2, with effect from 1/8/2011. So that is the first movement, my lord. So for among this writ petitioner, 1/8/2011, and the second.
Where the date?
My lord, in the second column.
Oh, second column, yes, okay.
Second column, with effect from 1/8/2001, and this is supported by the, my lord, relevant order issued by the government also. Then, my lord, the second stage, she was, my lord, placed in the second stage with effect from 1/8/2016. Now, my lord, each placement, my lord, in the highest stage career increments as per the rules. That what was never paid to us in spite of our representation. Now coming to my lord, writ petitioner number 2, from stage 1 to stage 2, he was given effect from 16/4/2013. My lord, from stage 2 to stage 3, my lord, 16/4 to 2018, your lordships. Now, writ petitioner number 3, he has been given, my lord, till filing of the writ petition from stage 1 to stage 2. Now, my lord, the same things, they were all denied, my lord, the promotional increment, which is, my lord, clearly categorically provided under this. Now, my lord, on the last occasion, if your lordship recollect, we filed several representations. It's not that we are sitting idle about the issue. We have been right from the beginning, we are filing several representations. These were not answered. And ultimately, in the year 2020, your lordship, that I have annexed, they have responded to our representations. That is at page 12, my lord.
Page?
Page 12, sorry, my lord, page 85, annexure 12. That is my letter from Joint Director, Higher and Technical Education, Government of Meghalaya, Shillong, to Joint Secretary, the Government of Meghalaya, my lord.
This is
24th August 2020.
This is a reply representation.
Lordship. Now, my lord, they have, in fact, my lord, this is a communication to the Joint Secretary where the Joint Director of the Higher and Technical Education, he acknowledged that we were entitled, my lord, to promotional increment for placement in each higher stage as per the rules. That has been acknowledged. So, in fact, while filing this writ petition, my lord, I was under the expectation this would be sorted out, my lord. They will not go and challenge. Now, my lord, what is their reply to this, my lord? I will come now. Now, my lord, I have read it. Shall I read it again? All right.
You have not read this one?
I have read it, my lord. Anyway, I'll read it. I'll read it again.
I will remember.
24th August 2020, my lord. With reference to the subject mentioned above, I am to forward herewith the letters enclosed as received from the Principal Synod College, Shillong, enclosing the representation of such and such Assistant Professor, Synod College, Shillong, Principal, Shillong College, Shillong, enclosing representation from Simati such and such Assistant Professor in English, Shillong College, Shillong, along with all enclosure wherein they have pointed out anomalies in pay fixation on being promoted from one grade pay to another grade pay that has arisen out of non-implementation of promotional increment as envisaged in UGC Regulation 2010 and UGC Regulation 2018 and CCS Revision of Pay Rule 2008. Insofar as UGC Regulation 2010 is concerned, the following clauses clarify the pay fixation formula on promotion from one grade pay to another grade pay, except from payment to 3 to payment 4. Now, my lord, clause 8b states that pay fixation formula recommended by the 6th Central Pay Commission as accepted by the central government shall be adopted for teachers and equivalent positions in library, physical education, etc. B. Clause 8a3 states that number of additional increments on placement at each higher stage of the AGP shall be as per the existing scheme of increment on promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in effective pay between the two pay bands, there shall be no additional increments on movement pay band from 15,600 to 39,100 and pay band of rupees 37,000 to pay band of rupees 37,567,000, my lord. These I have acknowledged. What has been excluded, my lord? If there is a promotion, otherwise, my lord, to put it simple, if there is a promotion from the post of assistant professor, which carry the pay band of 15,600, to the post of, my lord, higher post of, my lord, associate professor or professor, which carry the pay band of 37,000. In that case, they said, okay, no increment. But because there was a substantial rise. But movement from one grade to another grade, my lord, within the same pay band, as in the case of the assistant professor, increment is, my lord, provided. Now, next, your lordship, C, clause C of the UGC regulation mentioned at A is inextricably linked to clause 13.1 of CCS RP Revision of Pay Rules 2008, copy and close. Accordingly, while fixing the pay of promotion to higher pay band, additional increment 3% in the pay in the existing pay band is added to the existing pay in the pay band. The AGP corresponding to the promotion post will then be granted in addition to this pay in the higher pay band. Insofar as UGC Regulation 2000 is concerned, the following clause clarify the pay fixation. So even in this letter, they are annexing the how it is to be worked out. They are clearly referring to, my lord, this clause. They are clearly referring to clause 13(1) of Central Civil Service Revision of Pension Rule 2008. See, the calculation provided there.
Revision of pension rules,
my lord. Revision of pay, my lord. I'm sorry. Revision of pay rules 2008. Shall provide you, shall be applicable, my lord. And that's what, my lord, on the last token I have pointed out. For example, State of West Bengal. Now, State of West Bengal has adopted. And they have granted this increment, my lord.
Promotional. Is that a promotional increment? It's just when you advance, when you pay in the other pay band, that's...
But then otherwise, if your lordship look into the scheme of the thing, how it is affected, it's not automatic. There is a screening committee. You are required to put in a requisite length of service. You should have some requisite qualification, my lord, and thereafter there will be a screening committee. And then those APA marking and all those things are there. So this is, my lord, I think this is a promotion, nothing else. This movement, this all may not be eligible. So, my lord, even they acknowledge that it is. And the State of West Bengal, I said, your lordship, I have annexed and I have read it out, my lord. They have done the same thing. They have adopted, and whenever an incumbent has been placed in a higher grade, it was given as per the, my lord, as per the provision, that is clause 13(1) of the CCS RP rules 2008. Now, my lord, I have filed several representations starting from, my lord, 2011, my lord. But then again, your lordship, filing several representation, my lord, that may not be a good ground to condone the delay. I'll come into that because that was in lordship's mind. There is a delay since 2011. You have a cause of action. We are sitting over it. So I'll come to it. So we are not sitting over it. Several representations were filed, and ultimately it was answered in August 2020. And my lord will recall, my lord, situation prevailing in 2020, your lordships. Immediately we could have rushed to the court. Since this communication was there, one, we are under the legitimate expectation now government would act. Because this is a letter from the, my lord, directorate. So they had virtually acknowledged our right. So we are under expectation that within a reasonable time they would act on it, but did not act. Then this COVID situation and other things are there. That at the earliest in 2022 we filed this writ petition. So my lord, there is no latches and delay, your lordships. And then other thing will come. Your lordship has put up that questions, that delay. Limited. It's not limitation whether by delay we have, by our conduct, we have waived our right. Now, my lord, I think I should not trouble your lordship much, because very recently lordship has delivered a judgment. I was one of the party for university. I appeared for the university, my lord, then Dr. Dijan Sharma, entitlement of pension. So there, that question, I raised these questions. That initially when we joined, we said no. Then he waited for such a long time. So at this point, my lord, it should not be estoppel and all. My lord has referred to his judgment. Now, they say, my lord, that judgment Supreme Court has categorically stated, my lord, so far a right, my lord, arises by virtue of operation of law, my lord. Conduct of the parties are immaterial. This is a right under a law, my lord. This is 10 years, 20 years, whether I file representation, I do not file representation, immaterial. This is an obligation on the authority, my lord, to grant it. I'll give you a copy. This is recently, your lordship, February 18, lordship has delivered this judgment. Paragraph 15.
Oh, yeah, that Assamese professor or something.
Yes, senior counsel Mr. Theory appeared in that case. So, my lord, this is immaterial. So, I don't think that is a problem, my lord. That's in the meantime, my lord, from the first increment of writ petitioner number 1, the 10 years, that is absolutely, my lord, not be relevant. Because when something is provided by operation of law, my lord, the conduct of the parties are immaterial. But it is rather, I'll say, my lord, the state government should feel fortunate, my lord. For the delay, I could have made a specific prayer for granting interest. I have not asked it, but still it is open to your lordship, my lord. Lordship can always mold the prayer and direct them to pay the interest for the delay. Now, my lord, I'll come to the affidavit.
There is no appeal against this?
No. Till now, my lord, there is no.
It's already February now.
Yes, my lord, they should not reach time barred already. My lord, now coming to the appeal, my lord, I need to answer, my lord, few things. Now, my lord, Your Lordship, in fact, while issuing notice, Your Lordship just...
Now, come to the last part of this answered representation, Mr. Sen.
Which one?
The last paragraph of this 24 August 2020 letter.
Lordship.
Now, what happened then? See, if this is a categorical statement on their part,
Lordship.
You read the last part?
In
view of the above?
In view of the above, the government is requested to kindly extend the promotional increment while promoting the teachers of both government colleges as well as deficit college and aided colleges from one stage to higher stage.
Except for the pay bands also where the quantum is very high.
That is, my lord, from promotion from
3 to 4.
Yeah.
Now, what happened? Why he didn't act upon this?
No, I'll come to it, my lord. Let me, after that he can, my lord. That's a very interesting thing, very interesting thing, Lordship. I'll come to it, obviously, definitely I'll come to it, my lord. Then I'll start, my lord, one by one. Their affidavit, my lord. In fact, your Lordship, while admitting this case, Lordship, just ask me, your Lordship, why both the colleges together? You could have filed a separate writ petition.
Yes.
So, my lord, my learned friend had taken a cue from there. And he has elaborated, he has repeated why a single petition. It should be dismissed on that ground, my lord. My lord, there is obvious reason why I have done it like this. I was very conscious while drafting it. Because there is a common cause of action. A common question of law is to be answered. All of them are assistant professors, maybe in two different colleges, but both the colleges enjoy the same status, deficit colleges. Now, there is no dispute in the bar, my lord, that they have adopted the regulations, and it is extended to the deficit colleges also. Even otherwise, my lord, the sanction post of a deficit college, this is under the control of the government. With the budgetary allocation come from the government, appointment, government has a say, selection, government representatives are there. So I need not elaborate on these, your lordships. Now, my lord, the reason why I have done it, the only question to be answered in view of adoption of the UGC regulation, my lord, which categorically provided that in placement each higher grade will carry increment. That is the conduit. So that is which was refused to, my lord, these three petitioner by which they were aggrieved. So only question, your lordship, this honorable court is required to answer whether they are entitled to the promotional increment, my lord, on being placed in each higher grade of pay in the cadre of assistant professor. Now, my lord, kindly, your lordships, I will take my lord to Order 1, Rule 1. This is very clear. Order 1, Rule 1, my lord. My lord, we are after all guided by, my lord, though it is not applicable, but we are guided by a fair procedure. Now, Order 1, Rule 1. Say, who may join as parties, my lord? Who may join as plaintiffs? All persons may be joined in one suit as plaintiffs. Number 1, my lord, common transaction, that is not applicable. B, if such person brought separate suits, any question of law or fact would arise. Now, your lordship, just think for a moment. If I had filed 3 separate or 2 separate writ petitions, since common question of law, lordship would have clubbed them together. So this is one of the tests, my lord. So I fulfill this test, and my lord, it is absolutely, my lord, there being a, my lord, common question of law.
So you mean to say that this will operate judgment in rem for all assistant professors throughout the state?
No, I'm saying if they come, my lord, suppose they come 2, 3, 4, 5.
A common question of law. It is not deciding competing rights between the specific parties. It's a question of law that means that there will be operate judgment in rem.
That common question of law means if a proceeding is before the court.
Common question of law.
No, common question of law proceed. Suppose, my lord,
one I question of law is decided. Then anyway, continue. Yes.
My lord, one I'm at Senate College, but the question would have been the same thing. Are they entitled for the increment under the UGC, my lord? So my question is that I have not here clubbed together different cause of action. There is a single cause of action. And the reason, my lord...
Only that the dates are different of the appointment and the ability.
Nothing else. And another thing perhaps would have been relevant. I would have been slightly in a difficult situation if the government would have said, no, the management of the colleges have to answer here, have to step in here. But I examined all the papers. I found, my lord, they are no way concerned. And in their affidavit, they have considered. They have nothing to do. I'll come to that, my lord. So my humble submission, the first question, my lord, raised by them, that is not maintainable for filing a combined petition, my lord, absolutely, my lord, not tenable in law. This is very much maintainable, my lord.
Okay.
Now, Point number 2, there is also they are questioning the maintainability, my lord. Delay and latches. They are saying delay and latches. No, delay and latches, my lord, obviously, admittedly, the first, my lord,
cause of action arose.
First placement.
When did the cause of action arise?
First, my lord, for different writ petition. There is a different writ petitions, my lord. There are 3 writ petitioners before your lordship.
Yes, so for writ petition number 1, when did the cause of action arise? When was the first deprivation of that promotion?
She was placed in the higher grade in the year 2011.
Then?
2011.
So the recruitment was not given to her at that point of time?
My lord, no. I'm coming to it, my lord. But will the limitation apply here? That is the question, my lord. Because
no, limitation is sleeping over rights.
Exactly. Will that, my lord? Yes. Can there be a waiver, estoppel, acquiescence against a right, my lord, which is flowing from a statute? It cannot be. That's what your.
No, there cannot be any estoppel against law. Fine. That is given.
Yes. Yes. And whether it is law, that has been clarified. That has been clarified by the Supreme Court. But same scheme, my lord, in respect of state of Gujarat, has been answered. It is law.
The judgment's here.
Yeah, my lord, I'll place last part. So, my lord, the delay, what they are saying, my lord, absolutely, my lord, not tenable. Because this is something flowing from the statute. That is
right source from statute.
UGC regulation. And again, I pointed out, my lord, we were not sleeping over our rights. Repeated representations were filed. Though, my lord, filing repeated representation may not be a ground to condone delay. But here, delay will not come at all. And lordship will look into other thing. What they did in August 20, they have acknowledged my right. That letter from the Joint Secretary, he acknowledged our right.
That is undeniably a point in your favor.
He acknowledged our right. He's not saying you were delayed, you have waived.
Yes.
He could not have said that. He has acknowledged our rights. We have given him reasonable time, the government, to act on it. Unfortunately, they had not acted on it. And there was a time, my lord, of uncertainty, COVID and all. 22, we rushed to the court and filed these writ petitions. So, my lord, delay will not come. It is not a fact, my lord, that we are sitting over our right. That is incorrect. Government has acknowledged our right in the year 2020, your lordships. So, my lord, that is also absolutely, my lord, not tenable, that it is barred by because of the delay and latches. Now, my lord, other thing he's very casually saying in paragraph 7 and all, he's saying that I have not, my appointment letter, I have not annexed. My lord, how my appointment letter is relevant? It's not relevant. Because here the issue is this, I have been placed from grade 1 to grade 2, grade 2 to grade 3. Now, those letters, my lord, on the last occasion, I have taken your lordship to those letters issued by the government. I have annexed them. If your lordship wants me again, I will take you, my lord, to those letters. Shall I, my lord?
No, letters.
Letters I have annexed, my lord. So there is no dispute, my lord, that they were not assistant. They were assistant professor, acknowledged. And
we don't dispute that fact.
No, other part they are acknowledging. See, yes, they have been given their dues. Now, my lord, just he said for the sake, he should have annexed. In the absence of this letter, we are unable to answer and all, my lord. So that is something, my lord, absolutely absurd. Now, my lord, and one point he is saying, even, my lord, from where he is saying that UGC regulations, so what peer revision of teachers are concerned, this is nothing to do with teachers. It deals with other administrative officers of the universities. My lord, where from, my lord, is beyond my understanding. This is purely meant for teachers, and I have taken your lordship to those provisions. It may be extended to others also, but mainly it is with the teachers, and it very categorically says there are 2 payments they have provided. Then what are the, my lord, different grade for the assistant teacher that has been provided. But in spite of this, my learned friend is saying this has no applications of a teachers are concerned. Now, my lord, the most important thing, my lord, what they say. The other day, my learned friend was very casually saying that whatever dues are there, you can given. My lord, we are concerned with the promotional increment. And the promotional increment, we heavily relied on the common communication which acknowledge our right. Now, what is their answer to this, my lord? If your lordship come, please, to page 11 of their affidavit, paragraph 15. I'll just read. That in response to the evidence made in para 13 of the read petition, the answering deponent states that letter number such and such, dated 24/8/2020, a request may have been sent to the government to extend the promotional increment, but the same is a matter of policy decision. Well, where from this is Supreme Court has held? This is something flowing from a statute. This is a law holding the field. It is not your policy decision. It's not depending on your whims whether you will give or not. And my lord, I should not repeat, my lord, the scheme categorically say, my lord, if it is adopted, this has to be followed as a composite scheme, my lord, not part. Secondly, I have annexed those documents, again I will not go back, where the UGC has clarified whether only part of it can be followed. The UGC categorically said, no, you cannot. If you adopt it as a composite scheme. Each and every provision has to be followed. So, my lord, there is no, my lord, tangible grounds, my lord, opposing my writ petition here. So, my lord, I will conclude my submission with the decision from the Supreme Court.
Yes.
Give me that. Now, my lord, this is (2022), my lord, 5 SSC, page 179.
Page
179.
179,
my lord.
9 para.
My lord, this is online. Para, my lord, para. I am relying 27, 28, 29, and also 50.
50.
27, 28, 29, and 50.
The party's name is?
Party's name is, my lord, Gambirdan K. Gadvi versus State of Gujarat and others.
Yes.
Now, my lord, they briefly the facts, my lord. There, what happened, my lord? The State University appointed a vice chancellor, my lord, as per the requirement laid by the state law. So, these was ultimately taken to the Supreme Court.
On what ground?
It was challenged on the ground that this is not in conformity with the requirement laid down by UGC. And the state government has adopted that same scheme, that my lord, 31st December 2000, same scheme, and thereby they are bound by the UGC regulations. So the matter reached Supreme Court. Then the contention was this thing, no, we have a separate state rules. We are following the state rules, slightly different from the UGC, etc. There the Supreme Court, after hearing the parties, have, once you have adopted this, you are bound by this regulations, number one. And it was expected that once you have adopted, you should have streamlined and you should have fallen in line so far your laws are concerned in accordance with the UGC. You should have amended it. Then they held it is immaterial. Even if you have not amended, it is immaterial. Because subject education belongs to concurrent list. And if it is in the concurrent list, my lord, central government is competent to make law. And if there is a central law and if it is in conflict with the state law, my lord, central law would prevail. So here Supreme Court said court can always invoke Article 258 or 254, that repugnancy clause. If the state government is in conflict, then it can be declared, my lord, that central government law will prevail. So I'll just read out, my lord. This is not very long paragraph. 27. Page 27, 198. This is in the bottom.
Prior to enactment.
27.
Yes.
Prior to, my lord, shall I read?
Yes, read it.
Prior to enactment of UGC Regulation 2010, Union Ministry of Human Resource Development laid down a scheme, the same scheme they are referring, scheme of revision of pay of teachers, equivalent cadres in the universities following the 6th Central Pay Commission. The scheme provides fixed pay of rupees 75,000 along with special allowance of the per month to Vice Chancellor. Para 8 such and such of the said scheme provides that it is extended to the universities, colleges and other educational institutions coming under the purview of the state legislature, provided the state government wish to adopt and implement the scheme with certain condition. Inter alia financial assistance from the central government to the extent of 80% of the maintenance expenditure and remaining 20% shall be met by the state government. It further provides that payment of central assistance to implementing the scheme is subject to the condition that the entire scheme of revision of pay scales, together with all conditions to be laid down by the UGC by way of regulation and other guidelines, shall be implemented by the state government and the universities thereunder without any modification. in para 28, in the present case, the state government has adopted the said scheme dated 31/12/2008 by resolution dated such and such with effect from 1/1/2006, subject to the condition mentioned in the said resolution. Even in the said resolution, condition number 13 provides that the state government will publish the educational qualification as per the UGC instruction published from time to time, and quality teaching work days, norms, instruction, resolutions will have to be implemented. Next, my Lord, 21. It is not in dispute that the SP University is receiving central financial assistance under the scheme, and it is included in the state universities receiving central financial assistance as per 12B of the UGC Act 19. Therefore, having adopted the UGC scheme and implemented the same and getting central financial assistance to the extent of 80% of the maintenance expenditure, the state government and the SP University are bound by the UGC Regulation 2010. The UGC Regulation 2010 are superseded by UGC Regulation 2000. However, the eligibility criteria for the post of Vice Chancellor and the constitution of the search committee for the appointment of the Vice Chancellor remain the same. Therefore, the state of Gujarat and the university thereunder, including the SP University, are bound to follow the UGC Regulation 2010 and UGC Regulation 2018. Now I will take my lot to 50. Paragraph 50. No, she got it. It cannot be disputed. Yes, exactly, my Lord. It cannot be disputed that the UGC regulation are enacted by the UGC in exercise of the power under section 26(1)(e) and 26(g) of the UGC Act 1956. Even as per the UGC Act, every rule and regulation made under this Act shall be laid before each House of Parliament. Therefore, being a subordinate legislation, UGC regulation become part of the Act. In case of any conflict between the state legislation and central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 254 of the Constitution of India, as subject education is in the concurrent list of the 7th schedule of the. Therefore, any appointment Vice Chancellor, etc. So, my Lord, it's very clear, very categorical. What they are saying is a matter of policy decision. My Lord, cannot. It's not dependent on. They are bound by it. They are bound to act. So my humble submission, my Lord, this is illegal deprival. We have been deprived of a lawful claim, legitimate claim. Here the limitation will not come, but this flows from a statute. So they are bound to give us. And other thing, of course, Lordship has...
No, regarding applicability of statute, see, Mr. Isen, from what I understand, that there's no quarrel about that.
Lordship.
So once you adopted, you adopted. Number two is that only thing is that the reasons they have for deviating from the same, that's all. If the reasons are reasonable and whether the reasons are driven by how can they not implement them? That's the only question.
Yes.
If they
the other thing, Lordship's mind, perhaps Lordship has put one question on the last occasion: financial condition. But obviously, Lordship is saying because there is not a whisper. They cannot. If it is flowing from, they could have sought an exemption from the MHRD. That's a different thing. That this is our. They have not. They have accepted that 80% for 5 years without raising any objection. So this is too late in the day. And secondly, my Lord obviously is concerned because the Lordship is handling in a lot of cases from these corporations. I understand the situation, my Lord. They need 1,000 crores and all. Perhaps those things are also in your Lordship. But here the state government situation is not this. And here the amount, my Lord, I don't think, my Lord, it will be a huge amount. These teachers are here, my Lord, more of, my Lord, they are concerned that their right has been infringed, my Lord.
From 2011 till now?
Well, I don't think, my Lord, it will be a very huge amount. And other thing, your Lordship, state government do not have. And Lordship is away. Sanction posts, they have a budgetary allocation, including revision, increment. They have a budgetary allocation. State government has not come to this pass. They are paying their employees, your Lordship. So, my Lord, I don't think. And in the affidavit,
what's worrying the court is that other teachers are not being paid. They were sleeping on the streets. That's the only thing. Like, you know, so
the question is
that is a public, you know, like you say, like a public consideration, because, you know, whether it'll outweigh everything else that, you know, that the budget, you know, the budget allocation of the education department, like in view of court orders, like, you know, should not deprive the sector, which there no government can say they don't have money. But the thing is, how do you juggle the finances? You know, that's the only thing. So because sometimes in these cases, they accept, in good faith, it's accepted, even that representation says that you're entitled to it. And then like there's requirement that the government give you is like gratuity, percentage, interest, everything that they are entitled to it. And gratuity is a right also, you know, that kind of thing. But the only thing that comes in the way, I've noticed in cases here is that, you know, it is the financial constraints which prevents them, you know. Though in good faith in policy and decision, everything is fine. they want to give the employees their due. And they're right also, you should give them their due. But that's the only thing.
Yeah, my lord. They accept
Yes,
it.
they should have fall in contempt.
They sit over it. But the problem here is, my lord, this flowing from a statute. That is
Right.
That's my right.
No, even that alleged judgment which this court had decided, I mean, that is regarding that it was once you come under that old pension scheme, I mean, that kind of thing. So whatever it is, you cannot just put him arbitrarily in a new pension scheme because the right force from his right force might be latched on his part. He didn't approach, he didn't come. It was a lot of gap. It was a lien. It was a very confusing case. I think he came. He was from one college. He went to Jharkhand or somewhere.
Jharkhand Central University.
Then when he split from Jharkhand and he came and joined Nehu, then he was getting his prefixation done retrospectively from the old college where that is not as simple as this case, but that's the thing.
So, my lord, my humble submission, my lord, delay will not stand. There cannot be question of delay.
Yes.
So, my lord, we deserve, my lord, within a time frame to be released.
Yes.
And my lord, one more thing, last, your lordship, sorry, I'm very sorry, my lord, that last, because where they have stated, my lord, the pay fixation, because I was little worried, my lord, perhaps they will try to bring in the college management. Now, your lordship kindly comes to, my lord, page 5 of their affidavit, in the bottom. Last subpara of para 7 at page 5. Yes. In this regard, it may be appropriate to mention here that as per the usual norm and practice, pay fixation of the incumbents were normally being done by the respective colleges and the same are thereafter sent to the government. But in recent times, certain objection has been raised by the Directorate of Local Audit Fund regarding such fixation, as some anomalies have been found which appears to be regular. Therefore, the Education Department along with local fund audit are in the process of streamlining the matters relating to pay fixation, etc., etc. So nothing is in the hand of the management. And so far, my lord, this local audit is concerned, my lord, we have made them a party also. So I hope my learned friend is representing this office also.
Yes. Yes, Mr. Bharatsaji.
Firstly, my lord, this writ petition, the question may be on the whether they are entitled to increment or not. It's my learned senior, what he's telling is that it's a common question. But nevertheless, my lord, each facts have their own factual circumstance, my lord. Now, in this writ petition, all the facts have been jumbled. There is no clarity, my lord. The petitioners ought to have filed different writ petitions.
How do you see all the facts are jumbled?
My lord, date of appointment. My lord, what is the present scale they are drawing? Nothing is spelled out. They are only merely talking about increment. So at least it should be put to our knowledge. What is the present scale they are drawing? What is their pay structure at this point? What stopped them, my lord, to disclose that? Nothing. There is no whisper in the writ petition that what is their present pay structure which they are drawing. That at this stage they should have drawn this much. At such and such stage they should have drawn this much. There is no clarity, my lord. What scale they were entitled, what scale they were drawing. My lord, this is very confusing.
Yes.
My lord, as far as the UGC regulation is concerned, my lord. Another aspect, my lord, the colleges, they all come from two petitioners from the Sidot College, one from the Shillong College, my lord. Now, my lord, their appointments were made by the governing body of the colleges. They are guided by separate rules, my lord. Government is the approving authority. Now, as far as the salary grant is concerned, my lord, the government, because these are deficit schools, the government gives a certain amount of salary grant.
Yes.
Now, out of the salary grant, my lord, the petitioners get their salary. But nevertheless, my lord, the governing body of the colleges are important. The college ought to have been made a party. Now, my lord, there are certain allegations that UGC regarding that the state has adopted. Now, as far as this, to what extent state has adopted, my lord, as per my instructions, state has adopted only, my lord, as far as the pay scale is concerned and the placement, my lord. They have the UGC regulation.
Where have you said an affidavit?
My lord, the UGC, of course, this was an additional instruction which came subsequent.
You file additional affidavit, you can't take these points.
My lord, another aspect.
Their letter by which they have adopted. They have covered everything. Even in
No, my
their own
lord.
letter.
It is only
And
the
they cannot do also.
and my lord, this is not
You see only on pay scale
and only the pay scale, my lord, and the placement. There is no they have not adopted the increment, and UGC, my lord, here UGC is not a party, but UGC also recognizes that. UGC informed in fact, my lord, I think after 2010 the government had moved the UGC for reimbursement. There also, my lord, of course we don't have these communications here. UGC has stated that your state is not following the UGC norms in toto. You cannot expect any reimbursement.
No, toto, when you're falling foul of the UGC regulations, or it since you're not following, you're not entitled. These are two things.
My lord.
Suppose I'll just give an instance. Suppose now, like we are doing infrastructure.
My lord.
Okay, the central always gives assistance to the states. Okay, suppose you construct a college, right? Then centers will give 80%, state has put in 20% of the money. Okay, now centers gives 80%. Okay, then you start constructing, you're not getting anywhere. State doesn't put in 20%, and and then that building is stuck somewhere in the middle, correct? So state goes again, centers that will give us additional amount, for the thing, because escalation of cost. They'll see,
my lord,
where's the state share?
No,
you've fallen foul of the directives.
No, my lord, here what happened?
So you're not entitled to any additional amount.
The whole contribution, the 100% contribution is coming from the state alone.
In these salaries?
Yes, my lord. And this is not an isolated case. My lord, it is not a case that the government teachers are giving different treatment and the deficit college teachers are giving different treatment. This equal treatment is being offered to all. It is not an isolated case. There is no question of discrimination. My lord, as far as, of course, my lord, there due to oversight, my lord, we had received some pairwise comments from the local audit also, but initially because it was one paragraph, so we did not file it. But
see, that's the latches of the council, Mr. Marsaji. See, if the entire fact was brought for this court for pro-education, then what happened?
My lord,
it's like you feeding this court and then on the place what materials is.
My lord, the earlier affidavit was filed on the instructions which was received then, my lord. Subsequently, my lord,
you should have made a prayer affidavit, because here the state, and it involves a public policy and financial consideration. You should have prayed that you be able to file additional affidavit. We could have allowed it. Even pressure or objected, because if it amounts settling the issues, why not?
My lord. So, my lord, my humble apologies. If some time is granted,
at this stage now, after Mr. Sen has concluded arguments.
No, my lord, if I can, lordship, give me 5 minutes time, my lord. What he is saying, where from he is saying, his own letter say here. Now, government has adopted this scheme. Lordship can kindly, my lord, 2 minutes if I can take your lordships. Government has adopted these schemes, my lord. That is at page 42
so
of
much time of the court's been wasted.
My lord, what he is saying, from where he is saying, I know government in its letter, they are admitting, my lord, how this increment will be given. Page 46, your lordship. Come to my affidavit. This is government's letter, directorates, by which they have adopted. They are saying at paragraph 3, the number of additional increment on placement at each higher stage of SEB shall be as per the existing scheme of increment for promotion from lower pay scale to higher. However, in view of the same thing, that scale from pay band to pay 3. Now 8, fixation of pay on promotion, placement on account of career advancement scheme benefit after such and such. In case of promotion, placement, etc., it should be strictly as per the UGC notification. This is the letter on which I am relying. Now he is making a submission totally contrary to his own notification. This is something, my lord, very casual. At least they should look into their own document and say.
I have noticed the affidavit is very. See,
affidavit also like this, my lord, is very unfortunate.
My lord,
as far as they should answer this.
My lord, as far as
you do one thing.
My lord,
since it involves only under consideration only.
Because as far as the pay band is concerned, my lord, that is being given. That is the instruction.
I'm concerned with increment, your lordship. Again and again I am saying.
So, my lord, in that case, I may be allowed to file an
additional. Just adjourn it. We won't. You file it within 1 week.
My lord.
Let them be satisfied as we do. At the time of hearing, Mr. Kibasi.
No, it's okay.
Please that be allowed to bring some added material by affidavit. Praise allowed. List on so and so. Otherwise, see, it's a very tough case for you. That's why this court given the indulgence. It's not a 50-50 case. Remember that.
Lordship. Objection.
As 50-50 case,
Yes.
then we would, but then it's very tough. Because there are a lot of, you see, you have to keep one thing in mind. When down is that there have been concessions made by you already in that paper trail has been shown, Mr. Sen, especially the reply representation. There's a recommendation
My lord,
also.
as far as
Now,
the-
how are you going to turn that around?
My lord,
The
as far as the-
adaptation letter. They're
My
saying
lord,
the
as far as
increment. You know why they say the increment?
No, my lord, as
They
far as
should have
the
answered it.
as far as the last letter is concerned, my lord, of course that is
Policy
in my respectful summary is the opinion of the then director, my lord. Now it is for
Then
the
does
government.
it say anywhere in the affidavit, have you refuted that?
He said policy decision. Now can he improve your lordship? He said policy decision. That means it's at our whims. We may or may not. Now he's saying opinion. It should not be like this.
Yes. Where's MSP Kharmanlang?
Please, Lordship, Your Lordship, we have just informed that Mrs. Kharmanlang, she's not well today, Your Lordship. So,
Just because of this case, she fell sick.
no, Your Lordship.
Tell her to get well soon. What to do, Mr.
Lordship, in the morning 20 could be
Lordship,
mentioned.
we have just informed that that's the problem, Your Lordship. We have
And senior layer was here. Yes, argued some cases there. And it is
the lady
small
advocate
matters,
had,
man.
she had undertaken to argue the matter herself, and last time she had taken time to prepare the matter.
Yes, Lordship.
And so
For the last
Supreme Court now has given a lot of direction that these kind of matters can't be entertained anymore. Once it goes to DRT, OAS, it has to be take its course there only. And as the conducting council stated to be indisposed, this is a matter also. So.
Fully obliged, Lordship.
38.
Lordship.
Takut ne? Sorry. Okay. So hi. Yes.
Assam Rifles matter, dismissal from service.
Here the petitioner, my lord.
Was it heard? No.
No.
No time says.
Yeah, after 2 weeks.
Yes, or because the party does matter for 2 weeks. I thought it's a matter just for concluding. Yes.
What is the BSF matter?
Huh?
It's a BSF, that OBC matter, my lord.
That Meghalaya government acceptance.
My lord. OBC certificate from Assam.
That what to do about the matter? Because even I've done some research my own. It's just neither here nor there. What does one do? We don't have OBC list here.
No.
Then on what basis will the reliance be paid by the authority here?
Indirectly, the deputy commissioner has acknowledged the certificate of the Assam.
Indirectly, you see that's why I'm saying it's neither here nor there.
Definitely.
It's here because it's here because he accepted it. It's not there because it's not a norm. It's not a way of accepting. It should be in the list. Out here only scheduled caste list is there. There's no OBC list in Meghalaya. What to do? I mean, these matters I really feel for them because there has to be some closure.
After 2 weeks, my lord.
And if we decide this way, that way also, it might set a precedent which
Definitely.
open the whole gates now to be running OBC. That then OBC, and if let it come for 2 weeks also. Yes. Thank you.
Hello.